Can we go ahead and get him on the stand?
Yes, Your Honor.
Yeah, I know. You break his wrist off.
Ready for the jury. Mr. Atkins, can you hit play if we need you to do that?
Yes, Your Honor.
Okay. Thank you. I hope y'all had a pleasant lunch. Go ahead, Ms. Hilton.
We're going to resume at 1:29:42.
Fuck the man. Straight up. Oh, man, that's hard.
You may. And I don't think these little headphone things got. Y'all have those today? Yeah. Let me just make it easier. Instead of waiting to pass them all out, can y'all just step right back for a minute? We'll get them passed out in the meantime. Yes.
So, Your Honor, I think we need to give the jury some instruction here. The state they said they were going to go back
Right.
to what happened during the break, but I don't know. I don't think it's sufficiently clear to where we are in the timeline right now. I think we need to make it clear we're going back to the part that we skipped earlier that the state said they were going to go back to.
Is that what we're doing now?
I just inferred because we ended at 2 something that I went back to 129.
I don't think people are paying attention to what hour number you're saying. So
Okay. I can say that I can play it again and say we're going to go back. That's fine. I can replay
why
it.
don't you just say for the record what you're about to do?
And then can we just play the from the beginning again? To put
What
in
we
context.
just heard? Yeah, I'm sure. I'm not sure that needed to be like a bench conference, though. You probably could have just said that, but okay. It's all right. It's all right. Maybe if we'd had everything passed out, it would have been easier, but, okay. Yeah. So just let us know, a minute ago or before lunch, I said I was skipping some parts, whatever. I'm going back to them now. That'll be fine. All right. We're ready, I guess, for the jury. She's passing them out. We're ready. Thank you.
Your Honor, we're going to go back to the portions that we skipped earlier and play those portions now for the jury.
Okay. Thank you.
You're welcome.
Gotta get out of jail. Man, deep, man. Deep, fuck you, man.
Can y'all not hear it? Now it sounds better. And we'll let IT know yet again that we continue to have issues. Maybe they just need to replace that entire box. Do you want to give it a try? It always seems intermittent anyway.
Damn, man. Gotta get out of jail. Man, deep, man. Deep, fuck you, man. Fucked up, man. Straight up. Hey, go, man. That's hard.
Yeah, 1:30:39. We're going to resume at 3:20:51.
I just can't stop thinking I'm going to jail, so I can't even think right now. So
Relax.
yeah, I mean you ain't got to get all out today. Like I said, we working to get you not taken to Fulton County. Like if you're there, we're hoping just to get booked in and booked out.
So you may stay tonight. You can handle it.
Y'all can't go with us. My big mama and the baby can go. What you mean? Like move us? No. I'm not talking like you get booked in and you get booked out. I'm talking about you get booked in and you get moved to a different jail. I'm talking about it ain't
on the street, like basically protected.
I don't get in jail. I don't know. That's not up to you. That's not up to us. So I'm going to get a recommendation just for your warrants. I'm going for a gang charge deal? Yeah, you got a warrant for the gang charge. For the gang charge?
What you feel about the gang charge?
I ain't gonna get no money, man. I already got no money.
You don't need, bro. Honestly,
Ain't gonna do it.
I feel better when you're in jail because at least we know you somewhat safe. Exactly. My biggest fear is scooping you up off the ground and saying I told you so.
I'm just out there like this, I know how to watch my back. That's all I've been doing. I just had bad with these. I'm watching them, but I still just let stuff go and let them just come right back to me. But
It's a lot basically with what you learned about Lil D today. There's other stuff that you already know that it's starting to kind of add up, right? That stuff that happened between y'all when you like, wait a minute. You want to know who your biggest problem may be of all the people that I showed you, your friends. Because you so loyal to them.
close friends, Lil D and shit. I'm not loyal to them, like, cause if I was, I don't never just told them shit. Like, at some point, you had that loyalty to D and shit.
But now the loyalty, you seeing where it's at, where it's like,
Only one way, right? That's coming from you to them. So this, what can I do with this? Cause my big party coming up, man. It's in town, but I swear to God. I didn't even lock up. I tell y'all these spots in with the guns. I know these, man. I don't care. I put my face on it. I don't care, man. I don't care, man. My big birthday coming up. I just,
when your baby birthday?
on the 17th. June? Oh, yeah, I can see you ain't gonna be out by June 17th. Yeah, man.
And then if you want to be at your daughter's birthday, now that you locked up, ain't you thinking everybody thinking what he locked up on now? So now you being at the birthday, you make the birthday party hot.
Well, not even that. Cause I'm like, you know what they're saying about their gun? It's just like, oh man, you just don't worry about it. I mean, they lock you up there, they don't know why police got me. No, they probably trying to figure out.
I'm sure the word got out.
They trying to not talk about it, my baby.
You don't think the neighbors saw them? How many marshals ran up in there?
I mean, what?
How many marshals came up in there to get you?
There was nobody come outside.
You think? You don't think people heard all
There
that?
wasn't nobody outside. Like, you know, that's the good part of calling them. Y'all move in. But let me ask you this. This is what concerns me. Because we got the police report for that gun, the one that was found in the house today. And guess who it belongs to? Who? A DeKalb County police officer. No, these houses burglarized. No, I'm freaking houses either. You know, I only need Fulton County city. Yeah. I'm not gonna leave Fulton County at all. You know that. I'm gonna stay here. Yeah, you ain't gonna make it out by time for the baby party. I ain't gonna promise you that.
Look, as a father, I would want you there, but knowing what you bring, I wouldn't want you there anyway.
Man, if y'all can give me a house arrest and nothing, Lord,
I'm for real.
that's not out of control, but I can guarantee you they will be there.
But wherever you go, your armor brings problems. And although they ain't shot up lately, when you in the apartment and they come through shooting, y'all hitting the other apartment and other people. So by removing you everybody else good.
Everybody else is good. That whole time is out. You know, I ain't no shooting shit I've been out.
Thank God.
No, you do not think good.
I said, like, oh yeah, I ain't gonna do anything like that. Nothing.
It ain't because of you, it's because they already know we don't know who's fucking boss. It ain't because of you. It is because these niggas know how they do that. You know what I'm saying? All that shooting been happening was tips now. I mean, they the only ones that shooting.
But like you can't lie, it makes Shell and all them look like dubs. Because
the whole time they done shot at y'all, you ain't got
I can't kill hit one of them motherfuckers. Huh?
I ain't
That's what they thinking. They can't kill you. He that bad?
They ain't that. They like saying like, y'all outside this game. They're like, I'm telling y'all what's going on, and y'all still not listening. These people know how they do this. These folks, if they want to kill me, they want to kill me. Like, only shit I was when I heard about killing was these niggas thugs that somebody killing me. You know what I'm saying? I was running about them from the beginning. I mean, the shit they did, okay, like you said, I kind of figure who it was. I mean, like, dang, I ain't worried about nobody else doing that too. I mean, I just can't explain it. Like, this young man, Mr. Copeland, okay, I'm gonna break it down to you like this, young bro. Alright? And I mean it from the heart and from the soul. Once again, it had nothing to do with they knowing that you had something to do with it or not. Okay, that had nothing to do with it. Let me tell you what's keeping everything quiet. You understand that? See, when the first half get boxed up, then the second, the third, and the fourth, the rest of them motherfuckers gonna calm down because they all saying this. Sooner or later, them motherfuckers gonna get me next. So it's all gonna chill out. Motherfuckers, listen to me. When you and Kel was gone, everything was still quiet. One of you came out, she started trying to pick back up. Bam, bam, they jumped back on it, locked another motherfucker up. Everything ceased. Because they saying this. Them two motherfuckers right here know everybody that's in the game. They got the scorecard. Okay? So that's the bottom line. If you know me by my real name, my street name, my mama name, my baby mama name, my grandmama name, my big mama name, I'm fucked. I can't hide anywhere. So I'm done. Because the minute we stop calling you what we is calling you Killer Copeland, you know, okay, these motherfuckers know me. When we start talking about your baby mama, how to get shot up, and all this, you know, everybody know me now. Same thing happened to them. When you say, you want the problem we said. Okay. Y'all know, because this nigga got so much to prove. Y'all be like, trying to hide me in jail. It's not me. I'm not saying you nigga, man. Man, what I'm throwing, say you niggas said do it, man. Everything, he shot that gun, killed her. Shelly's doing everything. It's not me. Y'all be locking me up. Cause she ain't working, man. Stop right there. Take a deep breath. Man, cause y'all just saying right there, y'all trying to tear up and lock me up. Okay, I ain't retaliating. Not one time. I just wait. Listen.
Stop at 329.59. You said at 3:30.
I keep thinking, I'm doing shit. I'm not doing that shit. I'm kidding. I'm gonna go back to jail. I'm not get hurt nobody. If we thought you did one of these retaliatory shootings, we would have probably locked you up for it by then. But if nobody is saying anything, and you continue to let everybody paint you as that bad guy, you're letting that happen because you're not saying shit. And now that you're saying shit, guess what I'm gonna do? I'm gonna do my fucking job, and Shannon gonna be in there. It don't work like that. I understand it. This nigga, man. If you remember what you say, you gotta give us the opportunity to verify. Simple as that. You gotta be patient because we gotta do our, we don't do our, we gotta do our.
Well, who said?
No, it don't work like that. It don't work. At the same time, if you try to help us, I'm not gonna put you out there like that. So there's certain other steps I gotta do to kind of remove you as much as I can. You know what I'm saying? Your name as much as I can. So if you want me to just fucking say, shit, go ahead and type in my morning.
Hey, Shane, how you doing? Your friend, Woody.
Hey, I don't want to do it that way, but I don't want to do it that way.
Hey, Shane, shut
It's like
up.
I found to do. It's not.
It doesn't work like
I
that.
was told y'all at the beginning then.
It's not. You been in here. Well, it's January, though. You been in here 5 times.
It was, I know, but the nigga Tate them kind of like, they go out there.
You gotta worry about you.
You know, if I'm on your case, or this man on your case, this man on your case, we don't work like that. I can't speak for fucking BB and the rest of them, but I can speak for them folks. I'm speaking for the work that I do, and I'm not gonna put you out like that if you helping me with some shit. If you sitting there like John Silent, I'm gonna treat you as John Silent. And what did I tell you the first night we fucking spoke? I said, partner, I know you know more about what's fucking going on than you let out. You take me to a trip to fucking New York through Fulton California. I'm a straight white dude. I don't do fucking layoffs. I don't have no fucking time for that. Okay? You wasted everybody's time to get going.
All it do been avoided. A lot of it could have been avoided. From January 10th, what's the day? Today is June 10th. So we found out.
This is 6 months to the head.
If you would have said it from the beginning, he could have did his job. And I don't know.
There would be no need for you to be in this situation. Because everybody who took their eyes off my side in a situation like what was it? Who? And y'all still fucking boy. Y'all don't fuck with what y'all still fucking for. Alright, cool. I'm down there with that. And boy still walking around with his head high. Fuck with everybody say I'm out. Yeah. But listen what I'm saying there though. It did. I mean, I'm just sharing things like, hey, everybody gonna see this like, everybody gonna see what?
They don't see it. It's either they're gonna see it with you standing next to them, or you're gonna see it when you're away from them. Either way it goes, they're gonna see it.
As a matter of fact, you know what?
Why they care?
You took a jailhouse picture with fucking Lil Tick. Okay? And I go with Tick. Take a jailhouse picture with Tick.
We already did that.
You took a jailhouse picture with fucking Lil
Y'all had said yesterday you might have another speaker you could try as a backup. Let's try that, I guess. Is it plugged in?
Shit.
Okay? And I go with Tick. Take a jailhouse picture with Tick. Oh shit. I saw the fucking.
You may have to disconnect from the Zoom audio or something. Sorry, y'all.
There are like a whole lot of people.
Okay. I mean, in the meantime, I guess we can have them come down and try to do this reset also. Okay, more technical issues, calling for a technical issue break. I don't even think any of this is working. So if y'all would like to go spend time in the jury room, or we'll try to keep this as short as possible, but well, TBD on how long it's going to take to fix it. Oh, this is not American. Sure. Just make sure you've got cell phones with you so that we can get back to you. And I think it won't be more than a half hour. Maybe it'll only be 5 or 10 minutes, but yes.
Thank you.
Yeah. Woody done did so much talking. He done broke the PA system. I guess that's a good thing for Young Thug. It is his birthday. Salute to Young Thug. Allegedly, this is his 33rd birthday. I mean, so if nothing else go right during this trial, I would assume,
Thug will look at this like a win. Cause we need to shut Woody up. Cause Woody was going ham in there. Man, if y'all came late, my man said I'll wear a wire. Say what y'all need me to do. I'll do anything. You want Birdman? Wow. Detective Gaither asked him earlier, or in the previous interview. She told him she want to know about them bodies. And I don't know, what side of the field y'all viewing this from, but seems like they mainly concerned about Donovan Thomas. And I said that to say this. Allegedly, Fannie Pack Willis was known to be dating Donovan Thomas. Early on in the trial, we heard that somebody in the gang she was supposed to have been dating, allegedly. There wasn't no names given out at the time, or at least I hadn't caught wind of it. But now I see why they pressing the issue about Lil Woody being in court. Because if Lil Woody, without Lil Woody's testimony, we won't get it out, the information out about Donovan Thomas murder. We heard him earlier say he shot up Young Thugs. I mean, my fault. Rich Homie Quine's daddy's barbershop. He just told us who was all in the car when they rolled down and did the drive-by in the Infinity that Young Thug rented. But I don't think that we can really take a lot of his testimony with good faith, because he done told us out of his mouth himself that he was just bullshitting in there. He was telling detectives whatever they need to know to let them go. But on this interrogation, they got him, this interview here, this was the one that sent him to the feds, I believe, for 5 years. When he was up in the gym room, in the gym with a firearm in the book bag. And just from the outside looking in, old Woodrow, a.k.a. Lil Woody, because I had to give him a new name today, man. I'm tired of trying to figure out if it's Lil Woody, Lil Woody. But he in there rapping like an old man. That's on the, what was that we had back in the day? The Neighborhood Watch? He seemed like he part of the Neighborhood Watch right now, where he rapping. So over here at Fly High, we gonna call him Mr. Woodrow. Anyway, man, Mr. Woodrow done did so much rapping today. He done told these people a PA system up. The wires got hot. Started smoking up in the courtroom. He was about to request for a break anyway, so it don't matter. I mean, is it me or is anybody else in here tripping off for all these breaks they taking? Man, where y'all at? I see a few viewers on here. Anybody want to come up and rap? I'm gonna drop the link in the chat. If you want to come up and rap, just hit the link. I want to hear somebody else's views about this part of history that we viewing. As y'all know, it will be documentaries, movies, etc. about this case right here. This is the longest case in the history of Atlanta. We should have known that though by what it took them months just to come up with a jury. About a year. Speaking of the jury, I feel for them. $12, $6, $25, whatever they getting paid today, it ain't enough. Not an hour, a day. But let me touch on a topic that's a little more serious though. While they taking all these breaks, taking up to a year to pick a jury, having all the technical difficulties inside the courtroom, it's people sitting on that docket that has not been indicted. I can't quote the exact number of people, but it's a mass number of people. I will tell you this though, it's at least 19 people sitting on that docket and has been sitting on that docket for at least 5 years. Y'all don't believe me? Y'all can go back and skim through my videos. They interviewed old Judge Glanville, the previous judge that was on this trial right here. They interviewed him about all the people that's on the docket. Miss Fannie Pack Willis, they interviewed her. And they both pretty much gave the same excuses to me, which were lame. Now they saying that those 19 people that's been sitting in jail are mentally ill people, so therefore they can't come to jail and hold a proper a trial. I call bullshit. Cause after 5 years, whatever you was holding them on, and you probably got a few misdemeanors up in there to where they done did their time already. Let these people go. Now I'm not advocating for the criminal now. I mean, but it is such thing as a speedy and fair trial. And me myself, I'm gonna speak for Fly High Productions when I say this too. I feel like that's unjust. At this point, man, they might as well go and pull out the megaphone. It's been a circus so far, so let's not try to be all professional now. I know Brian Steele and Miss Love, they got some bottled up energy they probably want to release anyway. Been several times Miss Love say she'll just yell anyway. And I see a mistrial. Now, let me say this too. I don't know if y'all caught the early segment. At this point here, we got it, what, 3-part series to today's trial. But in part 1, I think old attorney Brian Steele was leaning towards a recusal. He was trying. It seemed like he was trying to warn the judge, like, I'm coming for you. I don't think they like her very much. I noticed Miss Loveland took a back seat since she came in, which was probably smart for the state because I don't think she's too fond of Miss Love. So as a strategic move, let's get Miss Love out of her face. And she haven't been interjecting as much as neither. Brian still been kind of quiet, which to his defense, you know, he only had an uproar when the ex parte came along. Well, him and Judge Glanville, they done had they spats back and forth here and there. But yeah, it sounds like I think I'm smelling a motion for a recusal. For the judge's recusal. We'll know by 5 p.m. today, I bet. I don't normally cover a lot of those motions because they get carried away with those motions. You know, because he'll put in the motion, the state got to respond to the motion, and man, it just had me too busy over her. You know, I do have a real job. You be tired. I can't keep up with all those motions though. But I do believe that we're gonna be hearing about, or we're gonna be hearing from Brian Steele. I think he done had enough of this judge. I see a lot of movement in the courtroom right now, but A lot of Miss Love back and forth, top of her wig. See if we can let them know we out here waiting. I don't know, squad. What y'all think? Think we gonna be seeing a mistrial with Young Thug and his crew, his gang, so-called gang, be getting hit with the RICO? What y'all think the Woody face card look like in the hood these days? I mean, if you on his internet, he seem to be out and about. He don't seem to be too worried about nothing right now. Going to every interview. But if these boys gunning for him like the detectives say, and if the detectives know all this, why haven't y'all done nothing about it? Why y'all pressing him to point these boys out? That's because y'all can't say that they done this for real. But I don't understand, Woody. If you tell on your guys, why won't you tell on the boys that's sending bullets at you and your family? It's your sister house, your mama house, you and your baby mama and your baby, and y'all doing a lot down there. And it ain't just in Atlanta either. It's all over. Got our problems down here on the home field. Memphis doing their thing. Chicago been running amok. Louisville getting in it. Louisiana. At this part of the segment, I just want to say, save the youth. Because whether y'all know it or not, that's what they gunning for. And that's been going on for a while. From the moment they took the daddy out the home, they was coming for the kids. If you ask me, they want the women to bow down to the men now. The men with power. Think they really care about the babies you having? Are you gonna feed your baby? I was always taught this, ain't nobody gonna care more than you. I don't know, squad. Maybe they They all in Judge Glanville's in his chambers, having a little birthday party for Young Thug. Come on, everybody chime in with
We're
me.
all gonna cross our
Happy.
fingers. Let's get the jury.
Oh, we back. We back.
And Mr. Copeland's back. And in the meantime, I'm gonna personally request that IT order a backup to this ASAP. Is that even working? Did it already go out again? It's already starting to not work. So did we try the reboot thing? I don't know. Doesn't sound like it. Is it? Okay. I don't know. It just suddenly sounded different. It's... So, anyway.
Sound like trash to me.
I think I'm just going to let the jury go home because it's already 3:00 and I mean, it works for a second. It doesn't work for a second. Okay. Well, is that going to work? Let's hear what that sounds like because this is not working. And say we need to back out ASAP.
The judge ready to dismiss the jury for the day.
Bullshit. I saw the fucking photo of Tick in the fucking jailhouse with you behind him.
Miss Love ain't trying to let him off that easy though.
I mean, they're not asking him any questions that he needs to answer right now. We'll switch everything back and cross our fingers. I mean, I hope that's where they have it turned to.
Because I'm a motherfucker who worked for the basketball players case. You know, bitch with me in no jail, I was sure. I'm looking at it, sure. So I said, that's killing cool. Well, sure.
Huh?
You didn't bring the ass down in this motherfucker right now.
Yeah, but I can't
You
hear
don't
you.
bring that motherfucker to the game.
What?
No, I mean, that part is difficult to understand. He said he could hear it, but he could not understand it, and she's yelling, but that's the way it works.
That's the way it sounded before. When she raises her voice, it sounds like that. So that's no different than it was before. So wind it back to wherever you're going to start it. Let's get the jury out. And salvage what's left of the afternoon.
Do I need to hear this?
What?
I'm saying, do I need to hear it?
Well, I mean, to the extent you were listening before, just continue to listen. If you were
You don't need to
listening
hurry,
before.
Woody. You know what you said.
When I had these on, I was hearing it, but like that, I can't hear it.
Okay, well, I mean, are you going to be asking him questions about this? You've already asked him, you already examined him, so.
I have to follow a few follow-ups, but it's stuff that already come in.
Okay.
Boy standing back there like they ready to get at Woody.
Your Honor, we're going to be asking him questions about it.
I'm talking about the whole defense.
Don't get too comfortable. You're not going to be staying. So I'm just going to be sending y'all home early. It's Friday, so happy Friday. We have not been able to come up with a sufficient solution that seems to last for more than a few minutes. Hopefully in the 10 days between now and when we see y'all again, we will have solved this issue. But for now, I'm going to release you with the reminders that you should not discuss this case with anybody else or allow anybody else to discuss it with you or in front of you. Don't try to find out any information about the case from any source. Don't discuss the case amongst yourselves. Don't listen to or watch or otherwise take in any kind of media or other accounts about this case or anybody involved in it. And have a pleasant weekend and week and next weekend. And then I will see y'all. What is the date of that next Monday? Monday, the 26th at 9 a.m. Thank you.
Me too.
You don't go anywhere yet. Hang on just a sec. And now this is working. But, you know. All right. Yeah, now it's working great, but it's obviously not working well enough to count on. All right, so we should need Mr. Copeland until Monday the 26th also, right? Okay. So Mr. Copeland, you can go for now. I'll be back here at 9 a.m. on Monday the 26th.
Can I go now?
You may for now, yes. Be back Monday the 26th at 9.
Miss Love do not like to see him leave. She wanted to get to the bottom of this.
There was one other solution that we could potentially use. We have a Mondo board at the district attorney's office. We were not allowed to use it with the configuration that we had previously where the jurors were sitting in front of the box.
I don't know what a Mondo board is.
I'll describe it. It's a very large computer screen, a very large computer on wheels that has a speaker attached to it, which may be loud enough for everyone in the far end of the courtroom to hear it undistorted, as well as allowing the jury to hear it.
Okay.
If the court is...
Do you want to wheel it up here and let's give it a shot?
That was going to be my request, yes. So I'm having someone bring it over.
Thank you.
Can I ask you a question about the Mondo board?
Of course.
Are you going to be able to hook that headphone up to it so Mr. Copeland can hear off the Mondo board?
It would actually be easier to reach the headphones with the Mondo board being where we anticipate.
We'll give it a shot. Somebody can stand in for Mr. Copeland since I've released him and see if you can hear sufficiently and undistortedly through the headphones. Okay, while we wait, why don't we get a jump on our next week's work? Who's ready on anything? Y'all should be ready on something by now. Okay. All right. On the PowerPoint, we should have states either written or ready to have oral response by now.
Well, actually, Judge, I had not finalized that. I know
Okay. Well, one side's ready, but I don't know how y'all are ready when you haven't given them your. Okay, so we're not ready on that. And I know that we haven't filed. Okay, let me ask you this. How about the issue of the Ryan motion to suppress his statement because of the incomplete Miranda warnings, or allegedly incomplete Miranda warnings? Okay, well, what was it that you were supposed to be doing by today? That
we were working on exhibits, witness lists with the accompanying exhibits for the next 30.
So when were you going to get all of this 3 pages worth of things we're going to tackle next week to the court and to the defense for their consideration? Sunday at midnight. All right, well, let me ask you this. On the Ryan motion to suppress, have you looked at it? Do you believe that the Miranda is complete? That the Miranda warnings are complete?
Your Honor, my position on that is that Mr. Ryan and his ability at this point to move to exclude that evidence would be untimely, number one. He has been convicted of it, and I believe that having heard it, there's an argument to be made on both sides, frankly. I hear what the officer is saying, and I think that there's just an argument to be made on both sides, to be fair.
Do you think that the law supports that if an incomplete Miranda is given, that the statement can nonetheless be used against the defendant?
Not in the state's case in chief.
And y'all didn't use it in the case in chief, did you?
Not in the previous trial.
All right. And yet you think that you have some law that would permit you to use it in some later trial against the same defendant?
That's not what I was saying.
Okay. Well, I guess I will just wait eagerly to see what it is that your argument is going to be on that. Just trying to think of some of the really easy things.
I am willing to speak with Mr. Williams more after we get a couple of other things situated.
Which Mr. Williams?
Miss D. Williams.
Oh, Miss D. Williams.
D. Williams.
Okay.
Yeah.
I thought you said Mr. Williams. Apparently I'm hard of hearing too.
No, so I will communicate with her, and if our position changes to such that it becomes a moot issue, she'll know and the court will know before Monday.
Okay. Alrighty. Well, I know that I haven't, Mr. Weinstein, gotten your promised motion to exclude Mr. Kendrick's first couple of hours of his statement. But the teaser was that y'all had just found out that he was represented by an attorney in an unrelated matter, and therefore law enforcement should have reached out to that attorney before questioning him in this matter. Am I right about what the basic theory is?
That's the basic theory, but
Okay.
I am not prepared to argue that today, and I am
Okay.
still working on the motion. And
Okay.
I think that Mr. Apt maybe clarified that would be filed tomorrow.
Yeah, he did. That just pretty much seems like black letter law to me as well. And I don't know, maybe there's some U.S. Supreme Court cases that have come out recently or since I took criminal law in law school that answer that question differently than how I was taught it. But so I will also eagerly await whatever your legal theory is.
Thank you, Your Honor.
Okay, great.
Perhaps that's why I'm still working on it.
Perhaps that's why. Okay. All right. Well, let's see. I mean, I don't know if there's any point in going back over the list that I have reviewed with y'all almost every day this week, because there may be nothing that both sides are ready on. And I realize that I'm a few days ahead of where I thought we would be, or when I thought we would be taking these things up, but just thought those two might be easy ones. Oh, do we have the ability yet to identify, other than whatever was in the wiretaps, any other co-conspirator statements that y'all on the defense maintain are late identified?
Your Honor, we maintain that all statements beside the 3 statements provided.
And I understand that, and y'all told me that before, but I don't know not the 3 that were identified before, not anything from the wiretaps. Are there others? And if so, what are they?
Okay, so the state, I thought that where we left it, and I wasn't even here that day, but I watched the video, that where we left it is that the state has provided hundreds of wiretaps and jail calls and still have not identified statements within those hundreds. So for us on our side to go through the hundreds, guess the statements that the state is going to may use, and then give them that list would take a significantly long time, when what the state could do, because I'm sure they have their case lined up by now, is to give us the statements that they've identified. And then if we have a legal argument against them, we can make that argument. And just for the record, Judge Glanville not only told them to provide all of the statements back in December of 2022, but after that, he told them to not only identify statements, but any evidence that they've identified, transcripts, any of the case, videos, that if they know that something is inadmissible, they need to go ahead and redact it. Tell us, hey, I'm going to introduce this. I've already redacted things that I know as an experienced litigator. It's probably not admissible. And then if we have any further redactions, to let them know. So that is the way this was supposed to move timely, not be a trial by ambush, not have the jury sitting outside waiting on us to get through the issues. These are the orders from Glanville. And Your Honor, respectfully, none of them get followed.
I'm noticing that. How about, I had asked about the January 10th,
The blurb at the beginning
that was,
of the day.
and you, Ms. Love, weren't here at the time, and we wondered if maybe you knew the origin of that.
I heard, and I do know the origin of that. So if I'm not mistaken, the court was inquiring, and there was a motion of sorts regarding the date at the top of the picture of Mr. Stillwell looking out of Mr. Williams' condo, contemplating. So that photograph, Ms. Hilton was correct in that Mr. Zachary told the police that he took the photograph a few days earlier or in the latter part of 2014. However, the date on the photograph comes from as it was placed on the social media page, the same way that the date of a posting appears on any Instagram or Twitter or whatever. The date of the posting is under the picture that is posted. So I didn't, unless I misinterpreted what the question was, the answer is that it was screen grabbed from Mr. Stillwell's account, and the date of the posting as shown on his social media page was January 10th, 2015.
Okay, well, it didn't, if it's a screen grab, is this the screen grab?
I'd have to see the one.
Well, it's what's filed in the motion in limine regarding admissibility of social media posts and alleged date of posting that was filed 8:15.
If Your Honor would allow
Sure.
me to take a look at it.
Ms. Persfield, can you hand that to her, please? See that little...
Oh, so.
Hand it back to me.
What that is, Your Honor, is that when a person is looking on the social media page and they want to know the date of a posting and they hover, it'll pop up or pop out in that manner.
Are you going to have somebody that is going to be able to testify to that?
We sure are.
And
Because it was
so
done on more than one.
somebody hovered, that date appeared, and then y'all took the screenshot or whatever, screen grab.
Two things. We, in not just this instance, in other instances as well, we not only captured it as it was shown, like if it with January the 10th, 2015 on the picture itself, but we also went back, the person who was looking at the social media page and hovered just to get that pop out that the court is looking at on that exhibit. Okay. So in multiple cases, we have a screenshot of a social media page with the date on it, and then a corresponding screenshot with the hovering where the date pops out.
So will you then intend to admit it as, or offer it as, are you going to have both of those things available?
Both, yes. I mean, yes, in terms of what we intended to proffer.
It would be the screenshot as you look at it, or the screen grab as you look at it.
Yes.
That has it the way we normally see it, and then also the hover, and then also somebody that is going to be able to say, when we see these dates, we have a reasonable degree of confidence that they actually mean what they say.
Yes.
And why?
We would have the person who first saw it and pulled it from the page, one, talk about what's on the screen grab, what's on the exhibit, and two, what the date means on the exhibit based on their understanding and knowledge of that particular social media platform. And three, we would ask, because I wouldn't see a need to admit both the original posting and the posting where it's popped out. But just as a next layer of confirmation as to the date that it was posted, we would ask, hey, how do you know? And then that person would say, well, you can also hover over the picture or the posting and the date pops out. And if the question becomes, well, did you do that? Yes, here's that exhibit with that pop out date.
All right. And is there any objection to, I know this shows like some comments also. Is there objection to that?
There is, and in my, as I was preparing an exhibit, we, in accordance with what usually has occurred, is we take out all the extra comments, and my prepared exhibit has that all taken out. So I just wanted to put I didn't want anyone to say I did anything to the one that I was putting in my motion. But can I inquire about that? Because just so the court understands, in this discovery dump 1 to 2, that's where this picture is, to my understanding. I know it's there. It may be other places. And it just says, it's a folder that says social media, and then there's a bunch of pictures. I don't know at this point, unless I missed it, I don't know who hovered over what picture, who collected this, or anything like that. So I'm just trying to understand who's going to authenticate how this was collected and what date it was and how they hovered over the picture.
Have we gotten to the production of that information yet?
Your Honor, we have that in, we've turned over, actually they turned over attorney work products. So that information is contained within a report that was authored by, I believe, Mr. Sprinkle in our office. So and that actual picture is addressed directly.
Okay.
So in as much as we turn that report over.
All right. Sounds like it's Mr. Sprinkle.
He's one of the people who addresses that report, that social media posting, and what is contained and what it shows.
the person who collected this photo in Hubbard, or is he just making reports saying, I've got a pile of papers that are in a file and one of them happens to be a picture of Mr. Stillwell?
The way that we got the photo or knowledge that we should be looking there is from one of the investigators, the gang investigator, Gaither, who was working on the case, looking through social media files. Mr. Sprinkle, as I understand his report and as I understand my conversations with him, and I will make certain that what I'm saying is absolutely correct, Mr. Sprinkle addresses in his report this social media posting, and then he talks about the date that it was posted. My memory is that he talks about the popping out, but I have to look at that. But I know that it is definitely Mike Sprinkle and Investigator Gaither that, and as with the rest of them, he addresses quite a number of social media postings, both he and other investigators that have worked on the case.
All right. All right, so at least we've got that answered. Or not.
It's been answered respectfully, Your Honor, but I guess this is just my way of saying this evidence did show up in their list of exhibits that they plan to introduce in the near future, and I am flagging my objection for the reasons I stated, and I guess we'll see how things transpire.
I mean, sounds like a maybe authentication objection, maybe.
Absolutely.
Okay. All right, so you're going to be put to the task of establishing that. Okay. How far away is the Mondo board? Okay, so Mr. Steele had brought a challenge to, and I may be misstating this, but I think to including, for the jury's consideration, I guess, overt acts that occurred prior in time to the RICO statute. Is that right? Or is it not? It could be not right.
I think it's right.
Okay.
For verdict. So the example that, the obvious example that I use in my mind is there's 191 overt acts.
Right.
And let's say overt act, the rental of the Infinity happens on January 7th of 2015. That's the only overt act that's proven. Every other 190 are not proven. There would not be a conspiracy because the overt act is not within 5 years. So my point is, I understand that the conspiracy allegedly continues and the state of Georgia can put in, if the court permits, different examples of predicate acts and overt acts.
And do you agree that they can put in for consideration overt acts that occurred further back in time than the 5 years?
Yes, the case law says that that's
So
appropriate.
is your argument just that unless at least one of the overt acts that the jury finds, I'm going to have to start over because I can't remember how I started that. Unless at least one of them is within that 5-year statute, then they can't be convicted. That's your argument. Yeah.
Perfect.
I mean, I think y'all agree with that. That it didn't sound like, that isn't what I understood your argument to be before, but if that's what your argument is, then yes, I agree that appears to be the law.
So I'm not hearing that he's asking that 190, that there's a form for that includes 190 overt acts on the verdict form, because, and this is the reason I'm asking about that, because any relevant information or evidence that is permitted at trial, that constitutes an overt act, The overt act does not have to be alleged on the indictment, and we certainly don't. That list that is contained within count 1 has never been represented as an exhaustive list of overt acts. And the overt acts that we introduce at trial don't have to be included in count 1. And if the jury finds, I mean, I understand what Mr. Steele is saying, and I'm not arguing with that last summation that the court gave. But my point is that I understood him to be saying something akin to, I want a special verdict form that includes the overt acts that are listed on the indictment, and I want them to say if they found this one, this one, this one, and if the ones that they find occurred prior to 5 years before the indictment, then they cannot find the defendant guilty of that count 1.
If only the ones they find occurred more than 5 years prior.
Right. That's
then
what
they
I
can't find them
saying.
guilty.
Yes. So
we're all on the same page then.
So as long as we're not talking about listing out the 191, because
we might be talking about listing out the 191, because how can I know whether they found one within the statute unless they say yes or no as to each of them?
Well, they could state, they don't have to. The reason that I would object to putting 191 is that it would limit them to consideration of 191. And if evidence of one that happened, for instance, during the course of this trial is not on the indictment.
It's not. And they can, I mean, we haven't gotten to that, but I would think they can consider that potentially. But if the only thing they find is an overt act is something that occurred post-indictment in the jail, and that's the only thing they find, they can't be convicted because you haven't indicted them for that.
Oh, Your Honor, yes, you can, and I will get that case law for the court.
Okay, well,
but definitely you
be
can.
interested in seeing how they can get convicted of something they weren't indicted for, but okay. I have so much exciting case law to look forward to.
Yes, Your Honor, the court does. They were indicted for conspiracy to commit, to violate the Georgia Racketeer Influenced and Corrupt Organizations Act. The overt act, that's count 1. The overt acts that are listed in the indictment
they were indicted for conspiracy and A and B?
No, they were indicted for conspiracy.
Okay.
And so all the jury needs to find after they find that there's an enterprise, that there's conspiracy, that people participated in it, only one person has to commit one overt act for the jury to find them guilty of count 1. And not by them, I mean all of the people that they determined were part of the enterprise. Conspiracy. Right. So if they find and believe that during the course of this trial, an act that is considered that can constitute an overt act was committed by either one of the defendants, then they have what the law requires to convict each of the defendants that they find participated in or conducted this conspiracy guilty of count 1. So the notion that you enumerate 1 through 191 overt acts, and that you limit the jury's consideration to whether or not the overt act that they find the one person committed is within these 191 acts is not an accurate statement.
All right, well, give me the law on that. That really wasn't what I was trying to address anyway. But I mean, obviously we're going to have to deal with that as well. What I was trying to figure out is whether Mr. Steele was arguing that if it was outside of the 5-year statute, those overt acts either couldn't be considered, which he's not arguing, or couldn't be found, which he's also not arguing. He's just arguing they can't be convicted unless at least one of them is within the statute, which we all agree to.
That's all he's arguing, then I don't have
That's all he's arguing, but I'm going to need to know, because you're going to be arguing against that kind of a jury verdict. And that they could find an overt act that occurred subsequent to the indictment and is therefore not contained within the indictment could form the sole basis for them being found guilty. And I'm going to need to know the law on that.
And to be clear, just to make sure that the court understands my position, not just that happened since the indictment. If there's an overt act that's not listed on the indictment that they find did occur, even if it happened pre-indictment, because we did not and do not have to include all of the overt acts committed in furtherance of this conspiracy. So that's the reason I would object to that.
You don't have to object to it. I'm not making a decision right now. I'm just saying I'm going to need the law on that.
Yes, Your Honor.
Okay. That an overt act not listed at all can be the sole basis for the conviction.
Assuming all the other elements are met, yes. That
Okay.
overt act.
All right.
Yes.
And then I'll find on your Bruton thing, on your Bruton assertions, have you been able to get with the state to see if y'all can work out something redacted?
No, I was going to put it in writing first.
And then get with them. Okay, that's fine.
Well, I wasn't going to get with them, but
Get with someone from the state.
yes.
That's fine. I'm not going to order you to get with Miss Love on anything.
You know, I have an interesting issue on it. If I can just
I know, but he minds getting with you. So.
make a statement, if it'll be in the motion,
Okay.
but I find it interesting. So Bruton and then the newest Supreme Court precedent, all this will be in the motion for everyone to see. But as just discussed, the RICO conspiracy in count one, I can't find a case yet, Your Honor. I will try to make it over the weekend. As soon as I get it, I'll send it to everyone. If I don't have it, though, I invite everybody. But it's the RICO conspiracy, and the Bruton then is not just like I eliminate everything with Mr. Williams that Mr. Kendrick said. Anything inculpatory about Mr. Williams, I assume I can't cross-examine Mr. Kendrick, so I put that down, the timestamp. I did the same for Mr. Stillwell. We did it together. So it's coming just easy for one motion. But he talks about Mr. Copeland, Mr. Arnold. All these people are supposed co-conspirators.
Right.
Well, according to the law of RICO, I assume, conspiracy, then Mr. Williams could be cleared of everything, but if he's found part of the conspiracy, then the act of Mr. Copeland is a act of Mr. Williams. So I'm having a struggle here. I don't want to, and I put it in here, I don't want to limit my redaction to just Mr. Williams, which I typically would do.
Right.
Okay, so I just want to highlight that.
Okay, well, that'll also be interesting. And that actually is an interesting issue. I'm not being facetious about that, which I kind of was about some of the other ones. Okay, well, to the extent that any of y'all can get your filings made, not that I want to spend my weekend reading it, but I'd rather be prepared for court on Monday than not.